going to switch gears totally. And we are now going to talk about real estate. Law of property, property law. Okay. All right, real property. So in law, we have two categories of property that we talk about. We have what we call real property and personal property. Real property is where we get the term real estate. And personal property is essentially property that is not attached to real estate. We also have different kinds of personal property. We have tangible, which is physical. Talked about that last week, well, not last week, the week before last. That is a good, right? A physical thing, like my coffee mug. That's tangible. We have intangible, which is like accounts receivable, things like that. And we have intellectual property, which are patents, trademarks, copyrights, and that sort of thing. So I want you to know the difference between these two. Real property is treated legally different than personal property. The law that applies when you sell real estate has different rules than the law that applies when I sell you a coffee mug. So what is the difference? So right here I wrote it out pretty basic. Real property is the law that involves the sale of land plus fixtures. Fixture, that's the word right here, fixture. Personal property is tangible that's not attached permanently to the earth or is intangible like patents and trademarks and licensing and that kind of thing. All right? So that said, let's talk about what we mean by a fixture.
Excuse me.
Yeah.
It should be tangible, like physical.
Tangible is physical, correct.
What about copyright? Is that physical?
That would be intangible. Non-tangible or intangible. So that's intellectual property, like a copyright. So tangible would be, like this or a chair. Copyright is intangible. And I know my handwriting's bad. And you don't need to worry about intangible. I don't really test you. So. Okay, page 101. Let's talk about fixtures. Yeah.
What do you know for the test on this?
Real property versus personal property, which I'm going to explain right now. And then I'll come back. I'll show you. So let's talk about the difference between real property and personal property, and that involves fixtures. So first of all, what is the idea? A fixture is an item, physical thing, I suppose it could be intellectual, physical item that is attached to earth in such a way that it becomes part of the ground. Best example I can give you,
Ceiling.
a ceiling, a building, exactly. So for example, these ceiling tiles right here, right? When those are at Lowe's or Home Depot, sitting on the shelf, and I buy them at Lowe's, that is personal property. That's a good. When I bring them back and I put them into a building that's attached to the ground, that becomes part of the real estate. We call that a fixture. So buildings are fixtures. All the components, the drywall, the built-in lights, all of that are fixtures. So it converts from personal to real property. Question?
What, no?
No? Okay. All right. Now, who cares, right? Who cares about the ceiling tile right here?
Wow.
Here's why it matters. When I sell you the real estate, all of the fixtures go along with the sale automatically, unless they're specifically excluded. So let me explain what I mean, real world. So let's say I'm gonna sell you this piece of land. Let's say it's a small acreage, like 5 acres. Okay? So there's a house, here's the house, and there's like a, barn over here, and we've got the hot tub, and fencing all around it. And we've got a garden with fruit trees and stuff. All right, it's a little acreage, right? So when I sell you this property, we're gonna enter into a contract. And the contract's gonna say, I will sell you this property, which is legally described as Lot 1, Block 2 of Monmouth Estates. And again, don't worry, it's way more detail if that's you want. I just want you to understand the idea here, all right? So when I sell you when I buy this property, or I sell it to you, you're gonna pay me the purchase price, and then I'm gonna sign a deed. The deed is what will transfer ownership from me to you. The deed says Lot 1, Block 2 of Monmouth Estates, Polk County, State of Oregon. It doesn't say, a lot of times, even the address of the property. That's called a legal description. A legal description is the surveyed area of the land in the county records. It doesn't say a house with 3 bedrooms and 2 bathrooms, a fruit tree garden, a barn, a hot tub, none of that. It doesn't say anything. Why? Those are fixtures. They go along with that legally described area of ground. Every piece of ground in the United States has a legal description, which is a survey somewhere. And when I sell you the property, I'm selling you the legal description and all fixtures. So I don't have to list out every single fence post, every rose bush, every little attachment to the ground. It's included automatically, unless I exclude it. So if I say, okay, I'm going to sell you this, but I'm taking that rose bush with me and I'm going to dig it up when I leave. And that's in the contract. So that's the idea behind this idea of a fixture. That is personal property, that is something that is movable, but you attach it to the ground in a way, like a building, where it becomes part of the real estate. Yeah.
Okay, so, well, obviously we wouldn't take like the lights or the ceiling tiles if you like sold this building or whatever, but you would take the projector screen.
Good question. So, electronics, appliances, etc. Refrigerator, washer, dryer. Is that a fixture or not? Here's the basic rule. If you can plug it into a wall socket, not hardwired, plugged in, not a fixture. Hardwired, it's a fixture. So that's a fixture. So if I wanted to take the projector from me, or from the building when I sold it, I would have to specifically exclude that, saying the sale does not include the projector in room 103.
See what the screening is too.
Yeah, same thing. I mean, it's attached, right? It's all hardwired in and all that.
Okay.
So that's the rule. Now, so like in most real estate contracts, you'll see a provision that says, I'm going to sell you Lot 1, Block 2, and I'm going to include the following personal property: the washer, the dryer, the refrigerator, the flat screen TV that's mounted to the wall, but it's plugged in, it's not hardwired, the lawnmower, the weed eater, and all that stuff, personal property. So that's part of the sale, is you list out what personal property is included. The sale does not include Grandma Oma's chandelier that's in the dining room, which the seller will retain. Because that's hardwired, but I want to keep it because I got it for my grandma. So I will exclude it in the contract. Now, why am I telling you all this? Real world. This is where I see a lot of disputes in the real world. People selling or buying real estate. And like the chandelier. I had that exact case where it was a young couple, they bought their first house. And it was a tract home. And they took out, when they moved in, they took out the builder's light in the dining room, which was just somebody buy at Home Depot. And they put in grandma chandelier. which was Swarovski crystal. Swarovski, thank you, yeah. So, I mean, expensive, really nice, right? So they go to sell their house, and they get a buyer. The buyer, they go to contract, they sell it, they go to closing. The buyer moves in, and the chandelier's gone, because they took it with them when they moved. But they didn't put that in the contract. So, yeah, they got sued, because the buyers wanted that chandelier, because it was, you know, I can't remember how much it was worth at the time, like $8,000. So they settled that case, but they ended up having to pay the buyers. So that's why if you're buying or selling property, if you like the big screen TV, if I'm buying it, buying your house and I want the TV to stay, I gotta put that in the contract. Vice versa, if you wanna take a fixture with you, you have to exclude it in the contract. Now for you guys, again, I just want you to understand the concept. So imagine a fence post. I buy it at the farm store. At that point, it's personal property. When I take it to my farm and I pound it into the ground,
Fixture.
now it's a fixture. If you know that much, you're good, all right? Do you want to come over and pound fence posts at my farm? I got a lot of them to do. Okay. So first concept on this page 99, again, real property versus personal property. Easy. Land plus fixtures. Personal property, movable or fictional, intangible, cyber, intellectual property, not attached to the ground, right? Okay. Let's move on.
That's all we need to know?
On this page, yep, simple. Keeping it simple. All right, page 100. %, list 4. So fill in the blank question, 100%. List 4, estates in land or interests. I may ask it either way, because they mean the same thing, basically. What are 4 interests in real estate? What are 4 different types of estates in land? Okay? So now what we're talking about, background, is when it comes to real estate, there are different forms of ownership or right to use property or right to limit the use of property that somebody else has. Permission, we have different levels of ownership or right to use property, okay? And these are the basic ones. There are way more than this. If you go to law school, you'll learn all about this. But this goes back to Old English common law, back in the days of kings granting tracts of lands to dukes, and then the dukes would grant smaller parts to like fiefdoms and shires, and that's where you get sheriff from, and all these different things, right? We don't worry about that here. What I want you to understand is kind of the basic, most important ones that we see. So, we have 2 basic types of interests. Possessory, non-possessory. Possessory means you either own the land or you have a right to use the land by contract or otherwise exclusively. In other words, you can exclude other people. You can lock the door. You own it, or you lease it, or you rent it, or whatever. Possessory means you have some right to either use somebody else's land or limit the way that somebody uses their land, but you don't necessarily have the right to stay there, to be there overnight, or for a period of time exclusively.
Renting.
Renting would be here. So that would be like a lease. Right? Okay, so let's go through these. At the top, the highest level is you own the land, ownership. We call that fee simple. Fee simple means ownership. Now this goes back to fiefdom, or a fee is considered ownership in the land, a bundle of rights, and it gets kind of all weird. All I want you to know, the highest right is fee simple, what we call absolute. We abbreviate that a lot as FSA, fee simple absolute. Typically, when you buy real estate, you want to buy fee simple absolute. You don't want to buy like a 99-year lifetime or 99-year use or whatever. You want to buy fee simple. Now, real world, there are different types of fee simple. The highest and best is fee simple absolute. That means you own all of the rights. You have the right to live there, well, depending on zoning, but possessory, you have the right to the minerals, oil, gas, coal, timber rights, water rights, gravel, farming, hunting and fishing, aviation, that is air space rights, all of those things. So land has different rights that are attached to it depending on the type of land. So it's possible to transfer rights but still own the land. We see that a lot in Texas and Oklahoma where the oil rights have been sold. You still own the land, but you don't own the oil anymore. Or here in Oregon, we see timber rights where you can own the land, but not the timber. The timber's owned by a timber company, they can come in and cut it down wherever they want and replant it. But you can build your house there, you just don't own the timber. So those are lower level of fee simple, and it gets all kind of way more than I want to talk about in this class. I just want you to know that's the highest level, all right? Next one down, a life estate. A life estate basically means it's kind of like you own the property as long as you're alive. But when you die, it automatically goes away. And then it's called revert. It reverts back to whoever has fee simple. So these aren't real common anymore. You used to see them a lot more in the 1800s, especially in the Midwest. But all I want you to really know for this class is that basically gives you the right to use the land, own it, rent it out, farm it, whatever you want to do. You just can't pollute it, or what's called waste, during your lifetime. As soon as you die, it goes away. There's nothing for your family to inherit. It reverts back to whoever the fee simple owner is. In fee simple, if I die, I can transfer my ownership to whoever I want in my will or my trust or whatever. We'll talk about that next week more. Life estate, when I die, it goes away. And finally, number 3. Okay? A rental, a lease. So that could be long-term, years, monthly,
Daily.
daily,
Like what?
hourly. We could have an hourly lease too, like, well, the Singapore airport, you can rent a room for an hour, right? If you know, for 6 hours or whatever. You
That's
see
nice.
those airports now all over the place, right? You want to crash out after a long flight. So, that's a bad thing to say, an airport crash out. So long-term, year, whatever, okay? So in other words, you have a contractual right to use the property, okay? So highest, lower level. So here's how it works. A higher level can sell a lower level. So if I own the property, I could sell you a life estate. You could then rent it out. But you can't go the other way. If you rent it, you don't own it. You can't sell it, right? So higher can transfer lower.
Number 2 is weird.
Yeah, you don't see those, they're not very common.
Doesn't make sense.
Well, I'll explain. All right, so let's say I have a house, and I want to live in my house for the rest of my life. But I want my children to take care of the rest of the property. So I transfer ownership to my children, but I hold back the life use of my house. This is real common back in the 1800s with farms. So the parents would give the farm to the kids, but they'd hold back their house. And so they'd have a life estate for the house, but the kids would own the property. And then when they died, it went away and the kids would just own the property. So you don't see it very often. This is the main one I want you to know, okay? All right, so possessory, that means you control the property for that period of time. Daily, monthly, for a year, your life, or you own it. All right, non-possessory, this is different. This is where you have a right to use somebody else's property for some purpose, or the right to limit how they use their property in some way, or you have permission. That's not really a contractually based permission like a license, that's just you have permission to be here like tonight, sitting in your chairs. That's called a license, you have permission to be here, at least I hope you guys do. All right? So, easement. Let's start with an easement. So let's say, okay, here's my land. All right. So, this land is my land, and this land is your land. See what I did there? I know, that's so bad. All right, so here's my land. So I'm going to build a house on my property. And this is Highway 99W. So I want you just to think like north of town here when you start to get out in the countryside or south. So we're out in the farm area. So this is all farm field all over the place. So I want to get, from my house, I want to build a driveway so I can get to the road, Highway 99W. Now to be able to do that, I got to go across your property.
Can't do this.
I can't do it unless I get permission from you, but I want more than that. I want permanent. So I want to put a road here for permanent. So what I will do is I will pay you money and I will buy an easement from you for a roadway.
You buy the land?
I will buy the right to use that strip right here. So I can put a road in. Also, I want to put utilities in. Electrical, fiber optic, sewer, water, natural gas, telephone, utilities. So I'm going to pay you for an easement across your property for a roadway and utilities. A permanent easement. Now what happens then, that'll be recorded with the county, and then this will attach to this land. So if I sell this land to somebody else, this goes along with it forever. A perpetual easement. Really common, you see them all the time. It could be for a roadway, utilities, it could be for an airstrip, it could be access rights, whatever, okay? So an easement is the right by contract to use somebody else's land, okay, for some purpose, yeah.
As is a reference, my uncle has a farm field at a farm, and he got approached to put a cell phone tower out there. Would that be an easement, or would that be something different?
To do what out there?
Cell phone
Oh,
tower?
cell phone tower? Cell phone towers are usually going to be in the form of a lease for a long term. Yeah, they'll usually lease like about an acre, anywhere down to just like the footprint of this room, depending on the size of the tower. And that's usually, most of the ones I see are for 25 years on the lease, or thereabouts. They're a longer term of a lease. So it's going to be a form of a lease. Yeah. Now, they may require, in order to put the cell tower in, if they have to go across somebody else's property for utilities, then they have to get a utility easement to be able to install it. But, yeah, that's usually going to be in a lease.
Usually, like if they put like power lines or whatever.
Exactly.
Oh, okay.
Yeah. All right, so easement. Now, there's another type of easement. That's where this allows me to use your land.
Air?
Yeah. In the air, right, in the air. Yeah, for airwaves.
Right?
Okay, but there's another type of easement. So now, let's say, here's the ocean. Right, we're at the beach. And so again, here's your land, here's my land. We have a nice view. You've got oceanfront property, that's awesome. That's on a hill. So I've got a nice view that looks over your land. So I don't want you to build a big super tall house or let the trees grow up that was gonna ruin my view. So I can pay you for an easement that will prohibit building more than maybe a 2-story house or allowing the trees to grow more than 60 feet tall or whatever. That way my land is protected, that view is protected, because that increases the value of the property, having a view of the ocean, or the Columbia River Gorge, having a view of the gorge, that kind of thing. It's called a vista, or a view easement, yeah, really common. All right. Other types of easements, hunting and fishing, things like that, yeah.
If the house below you got sold,
Okay,
then would the people have to buy that easement back
Yes.
if they wanted to build that?
well, no, okay, that's a good question. So there are 2 types of easements, perpetual and non-perpetual. A perpetual easement goes along with the land when it's sold, and it burdens the land that the easement crosses.
Okay.
So if this property's sold, the new buyers have to honor the easement. If this property's sold, the new buyers get that easement. Now, if it's non-perpetual, or there's a term for it that means it's personal to the person, then it doesn't go along. That has less value. So like hunting and fishing rights. So maybe like I have like a duck pond or something, and I want to give you access to it. So I might give you a personal easement or right to use it. But if you died or whatever, it goes away. Yeah. It all depends on how it's written. All right. So next we have number 2, condition, covenant, or restriction. Right. These are called CC&Rs, or deed restrictions. So these are really common in subdivisions. A whole bunch of houses, like in a neighborhood subdivision. And these are restrictions that are placed that will limit the kind of buildings that can go there, what kind of materials can be used, what color you paint the houses, things like that. So let me just kind of give you an example here. So let's say that I have, let's say this is, I don't know, 20 acres. Right? Just one big open piece of property. So I'm going to subdivide it because I want to build it out with houses. So I'm going to divide it up something like this. Make some lots. And then I'm going to sell each of those lots so people can build houses on them. And then this will be a road, and maybe I'll do a cul-de-sac or something like this. And I didn't do this very good. Have some other lots around there. Here's a road, right? So, I'm going to sell these off. I'm going to subdivide the property up and sell them to builders or people to build a house, right? Now, I want to make sure that when houses are built, they are more or less similar to each other, so we don't have all kinds of different architecture and different colors of houses. I don't want really tiny houses or really giant houses. I want things to be more or less in the same range, so things are more or less similar. Why?
So, no one,
Yeah, I don't want somebody coming in and painting a weird color so everybody else doesn't like them and it's a nuisance in the neighborhood. So it keeps property values roughly similar, right? So I may have a restriction that says, okay, cannot have vinyl siding. All siding on the outside of the house either has to be cedar, fiberboard, T111 or whatever, cement board, but you can't have vinyl. We're going to prohibit parking motorhomes in the driveway. We're going to not allow blue tarps in the front yard, covering your firewood pile. Your roofing has to be non-flammable material, either metal, asphalt shingles, or tile. No cedar shake roofs. Your colors, you have to choose from the following colors. Maybe 40 different colors on a color board.
this is your HOA?
Yep, and it's all enforced by the homeowners association. I'll put that on here, HOA. Don't worry about HOA, homeowners association, right? So that's really all you need to know. I'm not really gonna test you too much on that in this class, but these are really common. The main thing you need to know for the real world is if you're gonna buy a house that's covered by these, make sure you read them. Make sure that what you wanna do is permissible. I actually had a guy once, he was living in Southern California. He had beachfront property in Newport Beach, California, which he bought a long time ago. Sold the property for a whole ton of money, moved up here to Oregon, and was gonna build a house, this big giant house. And so he bought this great lot with a great view. And when I had the architect draw, it's like 13,000 square feet house, 6 bedrooms and a pool and all kinds of stuff. And so, yeah, he bought the property and paid the architect all kinds of money and went to get a building permit. And they said, well, the house is too big. The CC&Rs limit it to 10,000 square feet. You can't have that big a house. He didn't check that before he bought the property, so he had to limit down his size. Yeah, it cost him a few bucks. All right. Next is license. A license is permission to use property. Typically, it's verbal or implied and not written, where the rest of these are in writing. So basically, you have, right, I say, hey, yeah, fine, go ahead and go fish in my pond on my property, something like that. So it's basically permission. Now, it could be in writing, which is a little bit more formalized, but basically it's just permission to use. And then finally, number 4, a way of necessity. And this is basically an easement that if this property owner refuses to sell you that easement, and you have no other way to get to a public road that's reasonable, in other words, you can't go this way because there's a big cliff, and you can't go that way because there's a volcano, and this way it's a minefield. So the only way I can get there is to go across this property. This person won't sell it to me, so I can have the county require them to sell it to me. It's a lawsuit. I don't see that very often, but every once in a while. Okay, so that's where I'm going to break for tonight. I'm going to hand out your midterms here. So here's what I'm going to do.